Welcome to the debate. The 14th Amendment, ratified way back in 1868, really fundamentally reshaped American constitutional identity. It starts right with its crucial opening sentence defining citizenship. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
And you know that single vital sentence, the citizenship clause? It has this limiting phrase, subject to the jurisdiction thereof, which, well, it's become the central legal battleground, really, hasn't it?
We're confronting the question today, does this clause guarantee automatic birthright citizenship to children born here on U.S. soil if their parents are residing here without legal authorization? Right. And my position is that the existing Supreme Court precedent, it establishes a broad territorial rule, jus soli is the term, which confers citizenship based on physical birth within the country, regardless of parental immigration status. For me, the meaning of jurisdiction is tied fundamentally to physical presence and, well, legal accountability.
And that is really where we diverge. I argue that the phrase subject to the jurisdiction thereof has to be read more narrowly. It requires a political or sovereign allegiance that unauthorized aliens simply cannot provide, and therefore the clause excludes their children from automatic citizenship.
Well, my position is rooted in the established interpretation, the one formalized in the 1898 landmark case, United States v. Wong Kim Ark. Now, Wong Kim Ark, he was born in San Francisco. His parents were Chinese. They had a fixed permanent residence here, but they were legally ineligible for naturalization because of the Chinese Exclusion Acts that were in force then. Despite the government arguing against them, the Supreme Court ruled quite overwhelmingly 6-2 that he was a U.S. citizen. The majority held that the phrase, subject to the jurisdiction thereof, well, it must be interpreted in light of the common law, which traditionally defined citizenship primarily by the place of birth. So the court affirmed jus soli citizenship determined by the soil.
Is certainly a powerful point on the historical foundation. But Wong Kim Ark settled the status of children born to legal residents. Now, the parents may have been ineligible for naturalization, sure, but they were here legally, they were contributing to the community, subject to the full breadth of U.S. law, which to me implies a greater measure of allegiance. The debate today lies precisely in defining the scope of that limiting phrase, subject to the jurisdiction thereof, especially when we're talking about unauthorized presence.
But if we look at the exceptions the court actually recognized, they are very specific. Children of foreign diplomats, invading enemy forces, or Native Americans still owing allegiance to their own tribe. The court's logic was that these groups were excluded because they were not fully subject to U.S. law, right? Their allegiance lay elsewhere, overriding our jurisdiction. A child born to a legal resident or even a non-authorized alien doesn't fall into any of those categories. They are fully subject to U.S. criminal law, civil law, they pay sales tax, get traffic tickets. The Wong Kim Ark decision, I think, enshrined a broad rule that aligns entirely with the original purpose of the 14th Amendment, the anti-Dred Scott purpose to establish a simple, federal, race-blind national rule of citizenship.
I absolutely agree that the framers intended to overturn the terrible racialist basis of Dred Scott. But they chose to include the limiting language, and we can't just dismiss it as insignificant or surplusage, as the lawyers say. If the framers had meant citizenship to be granted solely based on being born here, well, they could have just stopped after all persons born in the United States. The fact that they added subject to the jurisdiction thereof forces us to ask, what kind of jurisdiction is required? The government's own argument back in the Wong Kim Ark case contended that this phrase meant subject to the political jurisdiction, which implies allegiance, not just, being physically present.
And that political argument didn't win in 1898.
It may have failed to convince the majority in that specific instance, yes. But the dissent, written by Chief Justice Fuller, maintained that U.S. law had already broken with that rigid English common law tradition of perpetual allegiance. They argued that the phrase subject to the jurisdiction thereof was actually synonymous with the language used just a couple of years earlier in the 1866 Civil Rights Act, meaning those not subject to any foreign power. And legal scholars who support a narrower reading today argue that Wong Kim Ark didn't fully appreciate the distinction between mere territorial jurisdiction, like the authority to prosecute a crime, and the full and complete jurisdiction needed to establish a permanent political tie. Unauthorized presence, I argue, fundamentally compromises that full and complete jurisdiction because the individual is subject to immediate removal. That shows they lack true allegiance. That's where I think the interpretation really breaks down when you apply it to unauthorized aliens. Wong Kim Ark addressed a child whose parents were legally residing here, just ineligible for naturalization. The status of someone present illegally, well, that presents a different constitutional complexity that the court didn't explicitly resolve back then. And furthermore, we saw later legislative action that seemed to question the absolute nature of jus soli. I'm talking specifically about the Indian Citizenship Act of 1924.
Okay, I see why you bring up the Indian Citizenship Act, but that context, I think, needs to be handled carefully. That act was passed to clarify the status of Native Americans, who, even after the 14th Amendment, were seen as members of sovereign domestic nations. They were thus excluded under the original Wong Kim Ark exceptions because they owed primary allegiance to their tribe. So the 1924 Act was really about Congress using its power to grant citizenship where the 14th Amendment's text, regarding tribal sovereignty, had created a kind of ambiguity. It wasn't, in my view, a broad statement rejecting the general rule of jus soli.
But the very fact that Congress felt it was necessary to pass the act, doesn't that show they didn't believe the citizenship clause conferred citizenship just by accident of birth for every single person? It seems to illustrate that the common law rule wasn't viewed as a completely comprehensive constitutional mandate for everyone, everywhere on U.S. soil.
But the weight of subsequent legal authority, especially the cases dealing directly with the status of immigrants, has consistently reaffirmed the broad reading. You have to consider the 1982 case, Plyler v. Doe. Now, that dealt specifically with the rights of undocumented children under the Equal Protection Clause, and the Supreme Court relied heavily on the precedent set by Wong Kim Ark. They noted that jurisdiction referred primarily to physical presence and territorial rule, not lawful entry. The Plyler court explicitly rejected the idea that 14th Amendment jurisdiction depends on whether someone entered the U.S. legally. Now, if Wong Kim Ark only applied to legal residents, why would the Plyler court lean on it so heavily when discussing the children of undocumented immigrants?
Well, the Plyler court was focused on the Equal Protection Clause, wasn't it? Asserting that undocumented aliens are still persons under the 14th Amendment for the purpose of how the government treats them. And we agree on that. But that doesn't resolve the specific question of citizenship under the Citizenship Clause itself. It just affirms they're subject to our laws. The question remains, are they subject to the full political jurisdiction? And the State Department's Foreign Affairs Manual you mentioned, well, that's an administrative interpretation. It's not a constitutional ruling from the court. It relies on what I'd call the maximalist reading of Wong Kim Ark, which is precisely the reading being challenged today.
Okay, let's turn back to the common law then. Chief Justice Marshall defined it by saying, the jurisdiction of the nation within its own territory is, quote, necessarily exclusive and absolute, barring those few historical exceptions. If an unauthorized alien commits a crime, we try them under U.S. law. If they earn income, they owe U.S. taxes, at least in theory. They are subject to our civil jurisdiction, our criminal jurisdiction, our regulatory jurisdiction. How can you argue they are fully subjected to our legal system in almost every conceivable way, yet somehow maintain they are not subject to the nation's political jurisdiction for the purposes of defining citizenship? It seems inconsistent.
That is the crucial distinction, though. They are subject to territorial enforcement, yes, but they do not owe the reciprocal duty of protection and allegiance that citizenship inherently requires. The fact that the U.S. government maintains the right to deport them, to remove them from the political community at any time, that proves that the jurisdiction over them is qualified. It's not absolute. Their ultimate allegiance remains tied to their home country. This is exactly what the Wong Kim Ark dissenters pointed to when discussing Chinese citizens back then. If Chinese law at the time made it a capital crime for Wong to renounce his allegiance to the emperor, how could the U.S. just automatically confer citizenship upon him simply by virtue of his birth here? The dissenters recognize that this tension, this conflict around allegiance, had to exclude the child, not just the parent.
I'm just not convinced by that line of reasoning, because the majority in Wong Kim Ark explicitly rejected the idea that the parent's foreign allegiance could somehow negate the child's birthright. And the constitutional purpose here, I think, is what matters most. The fundamental purpose of the Citizenship Clause, as part of the whole Reconstruction project, was to create birth equality, to constitutionalize the principle that if you were born in America, under the American flag, you are a citizen, independent of your parent's status or political deficiencies.
Intellectual disagreement sharpens understanding, as they say, and I do agree with the clause's anti-Dred Scott mandate. It was clearly aimed at ensuring birth equality for those formerly oppressed by slavery.
And the historical analogy here is quite strong, I think. Consider the reality that some enslaved people were actually smuggled into the country illegally, violating federal importation laws. Their parents were, by definition, unauthorized aliens who had broken U.S. law. Yet their children, born on U.S. soil, were undeniably intended to be citizens under the 14th Amendment. The parents' deficient, even illegal status was irrelevant to the child's citizenship. That, to me, is the core meaning of birth equality.
That historical example is indeed powerful, and it certainly speaks to the necessary breadth of the clause to protect civil rights. But, understanding opposing viewpoints strengthens one's own thinking. The question remains whether the framers, while intending to ensure birth equality for formerly oppressed people, also intended to eliminate all requirements related to sovereign allegiance, beyond just the specific exceptions for diplomats and invading forces. The current legal debate really focuses on whether contemporary unauthorized residency, which often involves, let's be frank, the intentional circumvention of the sovereign's laws, implies a kind of qualified, non-full jurisdiction that falls outside the intended scope of the guarantee. This is a massive constitutional issue today, given modern migration patterns that, well, the 1868 framers just couldn't possibly have envisioned.
But if the text says all persons very clearly, and the historical practice of the common law confirms that all resident aliens were included, regardless of whether they were lawful or unlawful, then we really must stick to the constitutional language and the clear intent, which was to establish an inclusive citizenship rule. We shouldn't be using today's political complications to try and narrow a fundamental constitutional guarantee based on an interpretation of jurisdiction that, frankly, failed at the Supreme Court over a century ago.
Well, the core issue remains that the text itself is perhaps not as unambiguous as you suggest. If it were crystal clear, we wouldn't be seeing these vigorous legal challenges to executive actions, or the flurry of amicus briefs currently before the Supreme Court arguing for a narrower reading. The political and legal tension today really highlights that the definition of full and complete jurisdiction is still very much unresolved, especially when allegiance is arguably compromised.
So we have explored the vigorous debate surrounding the Citizenship Clause of the 14th Amendment, framed largely by that 1898 decision in United States v. Wong Kim Ark. I maintain that the textual commitment to jus soli, supported by the common law tradition, and, I believe, buttressed by subsequent interpretations like Plyler v. Doe, mandates a broad, inclusive rule. This view grants birthright citizenship based solely on physical birth within U.S. territory, irrespective of a parent's immigration status, upholding what I see as the constitutional commitment to birth equality that defined the Second Founding.
And I believe that reading essentially renders the limiting language subject to the jurisdiction thereof almost meaningless, and it fails to adequately address the complexities of sovereign allegiance. I emphasize that this phrase requires careful attention to the concept of political allegiance and what constitutes full and complete jurisdiction. A narrower interpretation, which finds support in the logic of the Wong Kim Ark dissenters and the current challenges to administrative policy, is in my view necessary to define the bounds of citizenship in a way that fully respects U.S. sovereignty, particularly in the context of modern unauthorized migration.
It remains abundantly clear that the meaning and scope of this single vital sentence, truly a cornerstone of American constitutional identity, is still a matter of profound constitutional and political contention.
Absolutely. And with the Supreme Court having recently been asked to review this precise 14th Amendment question, I believe in September 2025,
following various challenges. Well, we are certainly left with more to explore in the source material as this incredibly complex issue continues to progress through the courts.